good morning, and good afternoon to in-house counsel from all across North America. Welcome to In-House Connect. My name is Shai Mahani, and I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunch time with us, and special thanks to our wonderful sponsor, Judicate West, and our fantastic presenters today, Rosemarie Chiusano and Ann Kotlarski, for putting together a fantastic presentation on how to resolve disputes with user-friendly mediation and arbitration provisions. For those of you who are here for the first time, let me give you a quick bit of background on In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE classes, which were then followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel from coast to coast, and we've been able to feature high-caliber speakers like the two we have today, who I'm going to introduce in just a few moments. This is our 26th event of the year, and I'm wondering, is this your first IHC event? Let me know. And I see we have a really, a lot of returning people today. So hello to the new 26% of people joining, and good to see you again to the 74%. Let's get to today's program: Alternative Dispute Resolution for In-House Counsel, Writing, Litigating, and Resolving Disputes with User-Friendly Mediation and Arbitration Provisions. Our panelists today are Rosemarie Chiusano and Ann Kotlarski, and I'm going to kick it over to Rosemarie and Ann to introduce themselves and get us started.
Thank you, Shai, so much. Hi, everyone. I'm Rosemarie at Judicate West, and I will be introducing Ann in just a quick moment. But I have to say, I'm looking at the chat, and I'm seeing people from all over the country. This is one of the coolest groups I've been a part of. Texas, my heart goes out to you. Chicago, Ohio. Hi, Santa Barbara. Colorado. I mean, this is just so wonderful. What a great concept, Shai. And thank you so much for having us today. We really, really appreciate it. So Judicate West, who the heck are we? Well, hopefully you'll listen to a couple of things that we say today. I am Rosemarie, and I am one of the founding partners of Judicate West. I started in this business on the East Coast. I'm originally a New Yorker. I've been in California for a couple of decades now and absolutely love the ADR industry. I've been doing it for 30 years and just absolutely love it. I've seen the arbitration mediation make a lot of evolution over the last 30 years. And so hopefully I can share a few tidbits with you today and a couple of takeaways that you will find helpful. Ann Kotlarski is a mediator that we work with, who mediates nationwide. And before she was a mediator with us, she was also a trial lawyer and tried cases throughout the country, and mainly employment cases, but also business cases, and represented businesses small and large. So let's just say she probably knows a thing or two to help you out. So that's a little bit about us. And about Judicate West, we provide all types of services: arbitration, mediation. We are based in California and have several offices, but we do cases nationwide. We do all types of matters, anything civil, tons of employment, medical malpractice, breach of contract, the list goes on and on, pretty much anything but criminal, not as much family, but anything relating to what you do, we have done. And all types of services: mediation, arbitration, focus groups, private trials, neutral analysis. And with Zoom, it's been pretty amazing because our outreach has been able to be pretty extensive. So that's a little bit about us. And now we're going to really get into the crux of the program. So arbitration. Arbitration provisions, as you know, are likely being upheld as they are in California in almost every state throughout the country. There's Supreme Court decisions, local Court of Appeals decisions that are upholding arbitration provisions. And you might have found yourself with a contract with a provision that was written 10, 20, 30 years ago. We call this the old school provision. It allows for absolutely no mutual agreement or flexibility. So what does that mean? You probably will read it and it will say one ADR provider, that is it. It dictates only one set of rules. It also will dictate to you how to select an arbitrator. Now, there are ways to get out of this provision, which we will talk about in just a moment. But this type of provision allows for absolutely no flexibility. And if you're working with an opposing counsel that is not cooperative and likely won't stipulate to any other options, you're going to be stuck in this type of provision. There's ways to deal with that. But then if you're also a transactional lawyer and you're writing arbitration provisions for your company, this is the new school arbitration. Let's all get along. There's a perception and a myth that arbitration, and it's true, there's a binding result at the end of it, and it's just like a trial. So you're going to represent your company in that type of a manner, strong advocacy. But arbitration can be, let's all get along experience to some degree. Let's say that. It allows for cost reduction. It allows for civility and an overall better arbitration experience. So that's the new school provision. How does it do that? I know it sounds insane, right? That could even happen. But how can you do that? State more than one provider in the contract. State at least two providers to give options. The whole goal here is to provide options. When you provide options, you provide a civility. You provide conversation with your client. You provide conversation with opposing counsel. And that just leads to a lot of good things. Offer considerations of the criteria of the experience, depending on the nature of the dispute. So in an employment matter where they're signing a contract to be employed with your organization, if it's a general contract, if this is a contract that you have with another company that you're doing business with, if it is a real estate transaction. So not all arbitrators are created equal in their backgrounds and experiences. And I'm sure you've all experienced that. So you can design that to include specific experience on the type of contract and dispute that it is. Also, offer a mediation component. That also sets the foundation for resolution. And would you have anything to add to that before we get on to the next slide?
Yes, I think what's important on the ADR providers is many companies have national arbitration agreements, whether they're rolling them out to employees, whether they're rolling them out to their various business partners. And all ADR providers are not created equal throughout jurisdictions. So one of the issues that I encountered in my private practice as trial counsel, and I do see as I'm asked to review arbitration agreements frequently as a component of mediation, is where is that provider? So for example, you may choose a national provider, but that national provider may not be strong in certain markets that are very key to you, whether that's a large state, someplace where you really transact a lot of business. So you really want to make sure that when you select providers, having options on that, maybe per jurisdiction, may be important, because you can find that both parties will say, well, look, we're not really finding the people that we need within this particular area. So I think it's very important that you look at all the different jurisdictions that you may be subject to arbitration in, and make sure you have a provider or providers there that will provide you with the level of service that you anticipate.
And when you were in trial practice, what type of arbitration provisions did your clients prefer? When it was the strict way with no flexibility, or the ones that provided flexibility?
When they started out with the strict ones, they usually found out that they got burned as time went on. And that's not a legal term of art, but it's the reality of what happens. So I would, to the extent clients really want arbitration agreements, I tried to build in as much flexibility and specificity as possible. So that's not just the ADR rules, but that also includes things that we would be talking about, whether it's under a stipulation or the actual arbitration contract, providing for civil rules of procedure. not just saying reasonable discovery, but really getting into the weeds on that. Or you're going to find yourself in a lot of disputes once you get that arbitration in place as to what's reasonable discovery.
And the stipulation is the key component. So if you find yourself with this old school provision where you're very limited to the provider and to the rules, this is another option for you to consider, where you have flexibility and you agree upon certain things with your opposing counsel, such as an ADR company or rules. The reason why it comes back to the ADR company is not for my personal benefit whatsoever, but you all have experienced when you do have an arbitration contract, more than likely it does have an ADR company in there. And there's multiple choices for companies. So you have a choice for an ADR company. You have a choice for specific rules, whether it's a Federal Arbitration Act or local court rules. You could mutually agree. So if you're stuck in that old school provision, have that conversation with opposing counsel. They may not agree, which you'll find yourself likely in court, but nonetheless, this is good conversations to have. The more that you can agree upon and coordinate in a stipulation, and you file that with the court so it becomes an order, your arbitrator has to follow it. Also, other things to consider is a completion date. Now, like my mother always said, it doesn't hurt to ask. So you may want to ask for a completion date. If nothing else, you could even put it a year out. But the whole point is it for not to linger and opposing counsel to be able to get granted multiple continuances. It's okay to have a completion date, and then if you need to continue it or opposing counsel at a professional courtesy, another 60 days. But having that completion date will absolutely help the cost of it and ongoing continuances. Also, the retention of the court's jurisdiction. That is another huge issue in stipulations, as all states are different. And Ann, I know you wanted to make a few comments on that as well.
There are a couple of issues with retention of the court's jurisdiction. Sometimes you will find that the party who is one of the parties to the arbitration agreement decides, hey, I'm not doing this. And they go ahead and they file suit in federal or state court. Now, the court may then compel arbitration and afterwards decide not to retain jurisdiction. But frankly, you do want the court to retain jurisdiction for one very important reason, and that is to enforce the award, whoever's favor it is in, instead of having to file yet another action for enforcement of the arbitrator's award if that becomes an issue. But I think one thing that's very important to point out here is many clients tend to think that arbitration is a private proceeding, and they think it affords some sort of protection of confidentiality. Unless your arbitration agreement provides for that, arbitration is not a confidential proceeding. Now, you may have a protective order that prohibits the disclosure of certain discovery, but the actual award itself, it is not atypical for the prevailing party to then go back to court and file that award. So it's a matter of public record. You also have to consider that from jurisdiction to jurisdiction, and this can depend upon the type of case. Some ADR providers are required by law, for example, in California for employment proceedings, to disclose who they have held arbitrations for and who the parties were and who the winning party was, and whether that was the plaintiff or the defendant. So again, to the extent that you're seeking privacy in the context of arbitration, you need to be very careful as to whether in fact that exists.
And the whole point of a mutually agreed upon stipulation with all of these added considerations, with both parties signing off to it and filing it with the court, is so you don't wind up with any gray area and ending up in front of a cray judge, not that that's ever happened before, to uphold how you were going to move forward with this arbitration.
We have a question. How does a stipulation on completion date work if the date is not met? What do you think?
Yes. So if you have a stipulation with a date in it, usually you will also share that stipulation because it's mutually agreed upon and hopefully submitted with the court. If it does become a court order, depending on the state. And I know in California and local jurisdictions it does, local states it does. So you would give a copy of that stipulation to the arbitrator as well. And if opposing counsel is playing games and they are not going to uphold what the provisions are in your stipulation that they've mutually agreed to and signed off, if it is a court order, the arbitrator and the arbitration company has to hold up the court order. That is the only way, the only true and tried way an arbitrator has 100% authority in jurisdiction is if they have a court order with a judge signing it as to the terms of a stipulation. So hopefully that answers your question. So we will move on to the next slide, which is governing procedures. So there are two types of procedures, and that's administrative and governing. Now, a lot of times you may feel that whether you have one arbitration provider in your contract or two, that your hands are tied. Your hands are not tied. This is your process. And I encourage you to do your due diligence. When you look at the different providers' rules and how they work with regarding their fees, and this also goes for independent arbitrators, take a look at all the nuances in their fee schedules. Because if it is a consumer arbitration, sometimes the defendant will pay the company will pay 100% of that. If it is a contract dispute and you're filing it with certain organizations, it is a percentage of the paid amount of the filing that you send in. There's other companies that have an estimated arbitration hearing, which is how many days. And then they also tag on a 10 to a 15% additional administrative fee. We don't work in any of that way. Our fees are very streamlined, but these are all things that we have seen. And many times I work on arbitrations where I get both sides submitting Judicate West a matter, saying that they've had another organization in there. They have done their due diligence on fees. They call us on a conference call together, which is the ideal scenario, and they want to go over all the fees because they're doing a cost analysis. Whether you do the cost analysis with opposing counsel or whether you do it independently, absolutely, I encourage you to do it. It could mean the difference of tens, if not $50,000, $100,000, depending on the complexity of the matter. Also the rules. So I only can speak for our company, but we have administrative rules and we have commercial arbitration rules. So the administrative rules will give both sides an idea of how we work administratively, aside from our fees. And then the governing procedures is what rules is the arbitrator and the lawyers are going to be governed by in presenting their case as it relates to discovery, motions, hearings. Are there appellate rights? And if they're not, what options do they have down the road? Also, administrative support, not only in case managers, but arbitrators. I find that the most efficient arbitrators are arbitrators that are almost like case managers, not that just have a phone call once, set up the arbitration date with counsel 6-8 months down the road, and then you connected them again 2 weeks before the arbitration. Proactive arbitrators set monthly CMCs to check in with the parties. How is discovery going? To match that up with your stipulation or your arbitration provision or your rules. They're guiding both sides to help no surprises or last minute continuances. Hopefully your case manager can help with that too. But those are all questions to ask the provider that you're working with or the arbitrator or the case managers that you're working with. And I see that most counsel do not do that. And these are things that are within your control to help you make the best decisions. Ann, do you have any comments on that?
Not on that, but I sure do on governing rules.
All right. Well, I feel like with arbitration, it is do or die. Many people feel like, oh my gosh, I have an arbitration provision. There is so much that is within your control, more than you think. And if you're not even sure what that is or what flexibility you have, hopefully you're connecting with the ADR provider or the arbitrator, no ex-party communication, of course. But all of these things are options, and you can design a process given the complexity of the dispute, your relationship with opposing counsel and the company, and your budget, because that is a very real thing. Arbitrators have different rates for different types of matters. With Zoom, now you could extend your demographic to perhaps different states and different practice areas. Obviously, arbitration is a binding hearing, so we do see that as more a preferred in person at times, given the nature of the dispute, but you have options. Another thing is the cost analysis is so important to the preparation of the award. The more complex the matter, you will find that the arbitrator will spend a lot more time in preparation. Sometimes you may have even gotten a bill towards the end or at the end, and it was unexpected. That's something also to manage along the way through your pre-arbitration phone calls and during. And the reason why is arbitrators look at that as their work product. Whereas mediation, you pay the fee, you have the hearing, it settles, it doesn't, there's follow-up work, you have your cost. But with arbitration, the cost can get out of those parameters because of the preparation of the award. And we're going to get into that a little bit later, but that is also something that you can consult with. And another thing is, make sure your arbitrator is available. So if you need a continuance, a brief continuance, and you want to reschedule, is your arbitrator only available 2 years thereafter? So these are questions to all have a checklist for while you're doing your due diligence for companies and arbitrators. I do have some sample provisions that I'm not going to go into detail with, so you have them on your slides. But what these sample provisions are, one's a general and one does mention Judicate West. You have insert your location. You could have a county. I'm sure you've seen all of these before. And this all incorporates what we previously discussed: rules, civil procedure, company, all that good stuff. The next one is a sample mediation provision. So if you were inclined to include a mediation provision, which we think is a fantastic idea, and we'll go into that in just a couple of moments, here are some options for you as well. In addition, you could include both. So this is a sample combo to introduce the mediation provision and the arbitration provision. And as you can see, it outlines the timeline for each of them. So you engage in mediation and you have X amount of days to do the mediation. If the mediation is unsuccessful, then you pursue arbitration. And then the arbitration provision has guidelines as well. So here are some options for you to consider. The beauty of this is that if you are writing provisions for your company, or you work closely with a transactional lawyer within the company, the beauty of it is you could work on it together from a litigation perspective, as well as from a transactional perspective, and create your own language. Of course, that's not unconscionable, because you don't want to find yourself in court on that one. Okay.
Well, before we
yes.
move on, I'd like to add a couple of points about drafting an arbitration provision. And I think there are 4 potential pitfall areas that I see that companies miss. And it's the company who's drafting this, whether it's to be engaged in with another company or with individuals such as employees. Number 1 is specificity about discovery rules. If you do not have rules of discovery, you just say reasonable discovery, you're going to be in a lot of disputes with your opposing counsel, fighting over what's reasonable and what's not. They may say 1 deposition, you may say 10 depositions. And keep in mind, every time you pick up that phone, unlike going to court, the arbitrator is going to bill you. So that's where arbitration is not necessarily always cheaper or more efficient. Because in my experience, I found many times I had opposing counsel calling the arbitrator over matters you could never go to court over. So try to hack out in advance in your agreement what will be allowable non-expert discovery and expert discovery as well. I think that's important. I also think most arbitration agreements are devoid of any mention of applicable evidentiary rules. Why is this a problem? Because then you get to the hearing, and even if you've had limited discovery, then your opposing counsel shows up with a list of 25 witnesses. And you say, hey, look, arbitrator, we only had 5 depositions each. And the arbitrator says, there are no rules of evidence. I'm allowing in everything, including the kitchen sink. You now have a hearing that is exponentially longer. So stipulate to evidentiary rules. I typically think if you have a national agreement, use federal rules of evidence. I think another important aspect is the appellate issue. Most arbitration agreements provide for very, very limited review. The concept being that it's binding, and only if there is some fraudulent or impropriety by the arbitrator is the arbitration award subject to review or reversal. You may want to consider a broader form of appellate review. And the reason I point this out is I think the one thing that both the plaintiffs and the defense bar will agree on when it comes to arbitration is the difference when you're in trial with a state or federal judge is that jurist is kept honest because there's a right of appeal. So you may want to consider that. Last but not least, check your jurisdiction and your applicable rules, because depending upon the type of arbitration that you are involved in, if you are the party who's enforcing arbitration, for example, an employer, you may likely be obligated to pick up the entire cost. So you want to make sure that your arbitration language provides for, we're either going to split the costs equally or as otherwise required by law. And that's it for my 4 points.
I love this question that Mitch asked. Many people hold the opinion that arbitration may not be necessarily cheaper or faster than traditional litigation, and the net result utilizing arbitration may simply favor larger companies who are infrequently in arbitration. Do we have any thoughts on that? And if it were true, do you believe arbitration is especially useful for certain industries where you would want industry experience, insurance, reinsurance? So I love this question. And I love this question for a lot of different reasons, and I'll try to be as brief as possible. When we started this company 30 years ago, we saw arbitration as a way for big companies to take advantage of the system. We did not feel that it was a fair enough process at that time because it was not evolved. So from a philosophical approach to the ADR industry, our company chose not to be written into contracts, not so much business to business contracts, but consumer contracts, mainly having to deal with car companies, lemon law issues, employment issues, medical malpractice, elder care facilities. We did not want to market to those industries. We felt at that time that arbitration certainly has a place, but it has a place when both parties agree to the process as well as to the rules. So we stayed out of that. As arbitration evolved, and we still do to this day, 30 years later, and I have to tell you, a lot of people thought we were crazy for doing it. I couldn't be more proud to not have done that. Because in the last 10 years, as arbitration has evolved, you have options. That is the whole point of this seminar, right? So we always knew there would be a time when arbitration would be a user-friendly process when both sides would agree. That would be the fairest process. So the arbitrations that we get, if we're written into contracts unbeknownst to us, it's because companies put us in contracts. We do not compel arbitration whatsoever. So with other companies out there, if there is an employment matter or a lemon law matter, and they are written into the contract, and there's even a pro se on the other side, they will compel that matter to go forward because they're in that contract. We will not. Even if we're written into a consumer arbitration provision, we will not, because we are not marketing for that type of business. The only way we would ever uphold a consumer arbitration where people are forced to come to us is if a court told us in a court order. That is the only way we could ever do that. Therefore, my whole point of this is when a certain company is written into a contract, a bank, a retailer, all of that, they are getting hundreds, if not thousands of claims with that particular organization. And so there is that perception that if they're a large enough company, they are going to have the business. If you're a one-off suing this company, you're going to have one arbitration with this company. The defendant is going to have hundreds or thousands of arbitrations. So that perception is very real. And that's why you want options. Instead of one provider, you want more than one provider. So you don't feel like it's an unfair process. I do believe that arbitration can be more expensive, and it's a very real thing. You can manage the cost. Hopefully, opposing counsel is on the same page with all of this. And if you can have a nice discussion with them on all these parameters, you have much more in control than what you think. The last thing I'll share with you is, and I only can speak for California, we have a very strict consumer arbitration law here, and mentions it before. It is not confidential as far as consumer arbitrations go. If you look on our website, you'll see consumer arbitrations. We are obligated by law to post publicly any consumer arbitration, med mal, elder care, employment, whatever falls in consumer arbitration within California, we have to publicly post it. The name of the matter, the dates, what the result was, not the amount, but if it was in the favor of plaintiff and defense and who the arbitrator is. Not only that, we have very strict conflict checks and disclosure rules. If parties are in an arbitration with an arbitrator and your arbitration is not for 8 months down the road, and you find out, well, we are under law to provide additional disclosures throughout that 8-month wait time. So if opposing counsel or that company has mediations, not even arbitrations, mediations with that arbitrator that you have coming down the pipe, we are obligated to disclose that as well. So that's for California. I don't know about other states, but that's also something for you to look into. So you're constantly getting this information. And if the laws are not as strict, ask for that information. See what rights that you have to find out what your opposing counsel and the relationship is with the arbitrator. So those are some tidbits for you.
I think one thing on expense that is important is I do believe from my own experience, 30 years, I actually really prefer jury trials for any number of reasons, including arbitration frequently is like chewing ground glass versus being in front of a jury. But setting aside that personal preference, the issue with arbitration where it becomes expensive is typically because you have an agreement that is not tight. I think if you have an agreement that sets forth discovery, that sets forth evidentiary, appellate rights, that sets forth deadlines and is specific and fair, that provides a guideline for your arbitrator and in effect can be a cost control in and of itself, which I think is really, really important. Because without those sorts of guidelines, you are frequently before the arbitrator just duking it out. What about this? What about that? And that's where the cost really runs up.
And you could use that preliminary case management call with your arbitrator to go through some of these items. I know our arbitrators, we provide them a checklist of all of these items. If it's not in a stipulation or your agreement, and you are discussing it for the first time, an arbitrator at that point should actually serve as a mediator to help you agree to the terms. So I would add that to your checklist, because a lot of our proactive arbitrators do feel like they mediate the discovery issues, or actually just not even the issues. That happens quite a bit throughout the duration of the process, but at least the terms and how that's going to unfold to be ready for arbitration. The other quick point of Mitch's question was, do you think it'll be useful for certain industries where you would want more experience? Absolutely. It just depends on that niche area. I've seen contracts where it has said construction defect. They would like an arbitrator, the arbitrator list of considerations, to be arbitrators with at least X amount of experience with construction litigation. I've seen it also with real estate. Insurance, I haven't seen it as much because it's such a broad area. But when you have specific industries like that, I think it is absolutely helpful. So what happens if opposing counsel, Ann, is not responsive to anything at all, and you have to make a motion to compel, and that's necessary? Now what happens?
So I think the issue on motion to compel, and I'm sure many of you are aware of the United States Supreme Court very recent decision came out last week. I believe it's Morgan versus Sundance. And if I got the name wrong, I apologize. I get everybody's name wrong. I think the issue on motion to compel that I see most frequently is delay by the party who's seeking enforcement. They may or may not assert it as an affirmative defense, and an answer you always should, regardless of what jurisdiction you're in. But for example, you decide, oh, we're going to go to an early mediation. Maybe we'll just propound a little discovery. I've had a case recently as a mediator where the parties have done virtually nothing since the filing of the complaint for a period of a year. Typically, the fact that nothing happened did not mean that your motion to compel arbitration would not be granted. Why? Because the party resisting arbitration has to prove that you've waived the ability to arbitrate. And the standard has typically been, I have been prejudiced by the moving party's delay. That is no longer the case. Under the Morgan decision for the United States Supreme Court, they are now saying that the FAA, the Federal Arbitration Act, does not grant any greater contractual rights just because you have an agreement to arbitrate. And that a showing of prejudice by virtue of delay is not necessary. What's the import of this? The import is that if you just sit around waiting to bring your motion, that could be in and of itself enough. In other words, delay is not going to inure to your benefit. And I always told my clients this: delay never, ever helps you. So I think it's important that, one, if you're going to move to compel, do it promptly. 2, meet and confer before you bring your motion. Try to find out from opposing counsel, well, what are their issues with arbitration? What is it about the agreement that they find so unconscionable, whether that's procedural or more or less substantive is usually the case. And that allows you to maybe stipulate in advance as to things that may be missing from your agreement, such as discovery, evidentiary, appellate, cost issues. Even if your counsel will not be specific, but you have a feeling that the court in your particular jurisdiction may raise issues as to your agreement, be prepared in your motion to say that you would accept the court blue penciling the agreement. For example, defendant acknowledges that there is no payment provision specified However, that does not invalidate the arbitration agreement. Defendant is willing to pay all of the costs. Get ahead of those issues in terms of that, and also submit a specific order for the court as well.
Wonderful. Thank you. So let's talk mediation. Oh my gosh, I think I'm feeling that East Coast energy. I just said talk. I hope that my mother was here for seven weeks from Long Island. So, so mediation provisions. You may feel that it's a double expense, but it's one that is so necessary. Here's why. In speaking to thousands of lawyers, they really feel that it can promote goodwill between the litigants, especially if you have an ongoing business relationship or would like an ongoing business relationship. That has been key. And that ongoing business relationship can actually be restructured in the mediation process. That could be the one thing that everybody actually wants and doesn't know how to get to. So there's a lot more to be gained than money, a one-time money deal, than a long-standing ongoing business relationship. Also, agreeing to terms, if possible, in certain aspects before the arbitration, in some ways, an informal bifurcation of it. So you bifurcate some of the issues that you feel could be negotiable, and maybe not the damages aspect, but some of the other issues. So you could discuss them, try to negotiate them, and you will save a lot more in arbitration. A 5-day arbitration can turn into a 2-day arbitration, really resulting in overall litigation costs and perhaps outside counsel fees if you're going to be hiring an outside counsel. And how did you, when there was an absence of a mediation provision in your arbitration provisions, would you counsel your clients to mediate and suggest it to the other side? Or did you look at it as a sign of weakness to propose mediation?
I never did. In fact, my practice was when the complaint hit my desk, because I did only defense work, I would pick up the phone, call my opposing counsel, whether I'd worked with them before or not, introduce myself, reintroduce myself, and I would open the door as to settlement. I never viewed that as weakness. I told them that I could see opportunities along the way. And the way I always broached mediation was, if that is something that you or your client feels would be valuable, because I never wanted to be in a position of making them feel like I was cramming it down on them. If you think that that would be a valuable option, we're open to that. Send me your list of mediators. Most of my clients did not have provisions that required mediation first, but I certainly always opened the door to that.
That's wonderful. And Emma just made a comment in the chat too, which I love, how she drafts the clause with levels of negotiation, going to mediation before arbitration. And I am seeing a lot more of those come through in so many different areas, like real estate, construction, just general business, just all of these different types of provisions now. And this is kind of like the new school way versus the old school way. So Emma, thank you so much for that comment. And I've seen a lot of companies call it their dispute resolution policies. So when you have those levels, maybe an informal discussion with HR is the first level, depending on the type of dispute that you are referring to, and then mediation and so forth. And so when it comes to some of these mediation provisions, what are some of the things to look at in this mediation initiation process? And I'll make one more comment as to why mediation provisions are good. When you need to make a motion to compel and you've tried to reach out to them to mediate to satisfy the contract, from what I've seen, sitting judges love that. What's the matter with you, counsel? You're not even agreeing to go to the table to try to negotiate? Look at all they're doing in good faith. What's the matter with you? So another pro. So mediation initiation. Some of the things that I've seen in mediation provisions, Our criteria for a qualified list of candidates, what was mentioned earlier. If it's a federal type of a issue, I've seen provisions where it says the neutral has to be a candidate with federal law experience, maybe location, particular area of law. Also, important to have a mediation completion date. You don't want that process to linger and there's multiple continuances because of various events. It just kicks the can down the road further for arbitration. Options for fees. And Emma, if you want to chat us what your mediation provision says about fees, we've seen the fees as mediation, a 50-50 fee split. Also, defendant will pay 100% up to a half a day mediation as a good faith gesture, or defendant will pay all of the mediation fees, depending on the contract and the type of dispute. Also, this is a little tip, and that is seek help from your ADR provider. Know who the mediators are, what types of experience they have, and also with the selection process. If the selection process is not indicated in a mediation provision, a provider can help you. Our goal, and I hope I speak for all ADR providers, is not just to throw the newest person out there to you and get you to work with somebody. It's about the experience. We want you to get results. So we want to match up the best mediator with what the type of dispute that it is. And we work with both sides to help you with that. And the reason why is we're a neutral person. So if you're the one with the contract and you have mediation in there and you're doing the initiation, your opposing counsel may feel that there's some type of perception of even the mediation process being lopsided. So we offer our help in all of that. So it could be the perception of the fairest process possible from beginning to end. But all of these things are things that are within your control. And the mediator is so key to, as you know, getting results. Arbitration initiation. So say you went to mediation, it was unsuccessful. Now it's time to pursue arbitration. Arbitration usually is an arbitrator strike and rank type method. So what we see most commonly, and this is not something always you have to put in an arbitration provision, it's usually in the providers or perhaps rules and how they go about providing the arbitrator and the selection process. So most common is a strike and rank. Now, if it doesn't say, or it just says strike and rank, you also have options. You could do a 3-panel strike and rank, a 5-panel, a 7-panel. So these are some options for you and opposing counsel to agree on in advance. If you don't know what your options are, hopefully the ADR provider will help you. So strike and rank is what we see most. Disclosures and conflict checks. So depending on the state, disclosures and conflict checks are very important. Once you have an arbitrator agreed upon or an appointed arbitrator, what we do as a company, and hopefully all the companies do this to some level, is we provide disclosures on past histories as well as a conflict check. So we have a very extensive survey that we give to the arbitrators because we don't know of personal relationships. We have their history, their work history as they're a neutral, but we don't have their relationship history. Maybe they sat on boards together. Maybe their cousin works at one of the law firms. I've seen that plenty of times, family members. I've seen their own doctors be witnesses down the road, and that ongoing disclosure is so important. So these are things that are very important. So know your rules with conflict checks and disclosures. In California, we do have a certain period that once your arbitrator is appointed, you could recuse that arbitrator with certain criteria. And there's a whole process for that that's in writing. But once that period expires, you are locked in. So make sure that you're working with either yourself, who's going to be doing the arbitration, or your outside counsel, and be involved with that process. As we indicated before, the written decision and the preparation decision is the arbitrator's work product. They take a lot of pride in it. They want you to understand, hopefully, why they arrived at the conclusion that they did. So they go through all of the testimony all over again on their own time. They go through all the documents that you have submitted to them before, during, and sometimes after. Sometimes there is oral argument afterwards, closing arguments. Sometimes there's closing briefs. So the arbitrator can do so much work after the arbitration process. Typically, they may even have 3 drafts of their arbitration award before you see the final product. Not that you're paying for all that work. You may or may not. I can't speak for all arbitrators. But what I can say is, depending on the dispute, if it's not as complex, you can guide the arbitrator as to, do you want a more abbreviated decision or a more lengthy decision? Because that might save you a lot of time. Ann, do you have any comments on that?
I think one of the things when it comes to arbitration awards and also just the presentation of evidence, something that I frequently did when I was practicing was I would ask the arbitrator, for example, on experts, many arbitrators don't want them unless it's unique to that particular issue. Your Honor, would you be interested in any experts on the following topic? And if so, what? Okay. First of all, that's very valuable information to get from your arbitrator. Then when it comes to briefing, many times I had closing argument, but the vast majority of times, in fact, I don't think I can remember an instance where I arbitrated a case where we did not do closing briefs, is to ask the arbitrator for guidance on what issues he or she would like to see specifically addressed in the brief. Because if you just run on and carry everything, remember, cover everything, the longer your brief is, the longer they're going to be going to follow all those different leads that you've put out there. So you can actually help control what the arbitrator is doing in terms of the award, each side teeing up the issues and asking the arbitrator what's important, what they want to see briefed.
I'd like to throw a question out to Cyberland and all you wonderful attendees today, because I'm going to ask Ann a question, but in the meantime, if you can chat us, if you had to give a mediator your top tip as to the best thing that they can do in mediation, what would that be? And Ann, I'd love to ask you a question because we get this question all the time. Mediation briefs. Yep. Should they be confidential? Should they be not confidential? Is brief better? Is more? Is less more? What are your theories on that?
Well, let's talk about that because it's near and dear to my heart. One, I have my own briefing guidelines, both on page limits for the brief as well as for exhibits. I think the single most important thing, because mediation has become a major event in most cases, it's sometimes more important than summary judgment, particularly in jurisdictions where you know you're not going to get it, given the nature of the case or the factual issues in dispute. Your brief needs to read like your opening statement to the trier of fact, whether that's a judge or a jury. So opening statement, first of all, eliminate all the adjectives. Cases are mediated and decided based on facts. Paint your picture with words. What is going to be your storyline to a jury? Why do you win? Your brief needs to point out why do you win. Your brief also has to have what I call the integrity component. And the integrity component is being upfront with the mediator about the challenges that you feel that you are going to face in that case, whether they are witness issues, evidentiary issues, and how you're going to meet those challenges. You should also identify the challenges you perceive your opponent is going to be dealing with and what you think those arguments are. This is a great way for educating your mediator in advance. I do not think if you are choosing a savvy mediator who knows the law, knows your industry, that you need to waste time on briefing the law unless it's a recent development or it's a very nuanced issue or an issue that the parties have seriously decided to dispute as a matter of law. Otherwise, focus on the facts, focus on those guidelines. When it comes to exhibits, many times I see parties just bombarding the mediator. The mediator typically does not need a copy of the complaint or the answer or discovery responses or your policies or procedures. Excerpts are fine. What's key? What is the key thing? How are you proving your case in terms of that? Highlighting, very, very important. So I think in terms of exchanging briefs, I really try to encourage my parties to do that in advance of mediation. There may be things that you want to share with the arbitrator that you want to be confidential. So you can do a redacted brief. In other words, I would not show the redactions, but I would have a non-confidential brief that I share with opposing counsel, and then a more fulsome brief with the mediator as well. And if at any time you want to hear about pre-mediation calls and a few other things, Ro, let me know.
Well, perfect timing, because one of the advice here in the chat from Brian is his advice is having a pre-mediation prep call after receiving the briefs. So tell us what, which I wholeheartedly agree with. So thank you, Brian. So Ann, what benefit do you think that has for the lawyers and for you?
Okay, so Brian, I don't always need the brief to have a successful pre-mediation call. I typically do have them, but many times my people try, but they don't get them in on time or before the call. But here's why I think pre-mediation calls are so important. And if your mediator doesn't offer it, reach out to your mediator and ask for it. You're paying a lot of money. You deserve the full service, start to finish. So pre-mediation calls, I think they're important whether I'm talking to the plaintiff's counsel or the defense counsel. It is my opportunity to speak with you outside the presence of your client about issues that may concern you. That can be who your decision maker is going to be. Is there going to be a carrier there? What's your relationship like with that carrier or adjuster? What issues do you want me to be aware of and sensitive to? What has been the previous history, or is this a brand new client to you? What are the challenges that you want me to be aware of in your room? Are there triggers that are going to send your decision maker or your rep or your client off? If we've got insurance, where are we on the SIR or the deductible, whatever you want to call it? What are the policy limits? Is it a burning policy? Where have we gone through? These are so many things that we can cover in a call that you may not be comfortable putting in a brief. And here I will draw a distinction. Where I see consumer arbitrations, for example, in an employment case, defense counsel is going to need to share their brief with the in-house counsel or the decision makers. And you tend to write that brief more as an advocate, and sometimes it's not as even-handed as a mediator might want to see. And you have to do that because that's part of your client relationship, and I get that. But this pre-mediation call is your forum to go off script and let the mediator know the challenges that you may have in your room or the challenges you perceive that the mediator may have in the other room. So always request it, even if it's not offered.
I agree. I've seen a lot of times lawyers work with mediators for the first time and they haven't had a pre-mediation call, or I've heard stories of this, and they're meeting the mediator for the first time on game day. And there's nothing like having a rapport with the mediator, even if you haven't worked with them before, through that phone call, So when you see the mediator, you can say, so nice to see you again, or so nice to meet you, and thank you so much for your call. You know, it shows, if you have a client with you, it shows that you have that, you've done your homework, you have the relationship, and it seems to have, you almost hit the ground running versus the get to know you in the first half an hour. So I highly, highly encourage it. So it looks like we're out of time for our presentation, but we would love to see some questions. I did see some throughout the chat. So Shai, maybe you can direct us a little bit on those.
Yeah. So first, thank you again for a really energizing presentation about arbitration and mediation. Can you speak to the concerns about mass arbitration in the employment context? How can arbitration agreements be structured to avoid mass individual filings from claimants, thereby creating significant upfront administrative costs to the employer?
Okay, so that sounds like the Uber case. And here's the issue. When it comes to arbitration, if you go with that, you are making your bet. So, for example, you will see a typical employment agreement will provide for class action waivers. So that's a great thing. And, you've now avoided a class action. But can you now avoid all these individuals, whether it's a couple hundred or whether it's 1,000, from filing arbitrations? And the case law that I'm certainly familiar with is no, you can't. You can't have it both ways. If you opt out of either a mass or class action through utilizing an arbitration agreement, that does not preclude people from bringing the individual claims. And that is a major, major cost driver. And we've seen multiple pieces of litigation throughout the country filed by large employers who have tried to do that and not successfully so. So, that's certainly an issue that I see in mediation. Is I will have a plaintiff's counsel tell me, we don't care about the class action waiver. We're going to bring a series of individual claims. There is also the issue in certain states where California is one of them, where we have representative actions which are not subject to arbitration. So you still have that double-edged sword where you can be in both state or federal court and in arbitration at the same time.
And that applies to the administrative cost as well, unfortunately.
Right.
When they're filed separately, there is an administrative cost per file. So it's unavoidable, unfortunately. So hopefully the majority of them settle.
One thing that does come to mind is if you are facing that, you will want to have an arbitrator who can perhaps come up with a streamlined process for handling the claims. So, for example, even though it's not a class action, a stipulation, whether it's as to dates of employment or certain specific factual issues or refining the legal issues. In other words, trying to narrow the scope of the arbitration for each individual kind of on a broad basis. I think that is something that I have seen done, and I think some of the more creative arbitrators are sitting there and doing it so that they can click through those arbitrations pretty quickly.
Mass arbitration is a huge, huge topic. It's, there's a lot of businesses out there that are concerned, frankly, about mass arbitration filings. Do you have any, advice or experience, with these types of, matters? I wouldn't say type of claims, but type of matters. Is it, becoming more prevalent? Do you see it in your, practices? Any advice on mass arbitrations?
In terms of, again, I typically see it as a lever that's utilized during mediation, that, that there will be a series, like an onslaught of arbitrations that will be filed in terms of that. I don't really see it happen typically, unless you are really dealing with a very, very large employer. One of the issues that you sometimes get with smaller employers is they're hoping to utilize that in the context of mediation to up the value of the settlement and saying, okay, we can either opt to go forward with 1,000 arbitrations, or you can pay me more to avoid that. In other words, it doesn't really go to the value of the legal claim, the liability, or the damages, but really using the cost of arbitration as a lever to force a higher value settlement. And I do see that quite frequently. Now, there is a caveat to that. It depends on who your defendant is, because not all defendants have an equal ability to pay, which, by the way, is one of the issues I explore in pre-mediation calls, because nobody likes surprises except at their birthday or the holidays. So the last thing I want is a defendant to show up and at 3 p.m. say, oh, by the way, I can't afford arbitration, or by the way, I need a payment plan, this sort of issue. But there's no way to avoid that threat if your arbitration agreement is structured such that you've said, hey, no class actions. The best you can do is you can really realize that this is why it's being used, is really to increase settlement value most of the time.
Which, if I had to put a statistic on it, which this is not a formal statistic, but in terms of employment arbitrations or as a consumer type arbitration, I would say of those type of arbitrations, about 60 to 70% do not go forward in arbitration. They settle in mediation. So it's there to kind of force the process, but both sides wind up agreeing to mediation, even absent a mediation provision. A business to business type dispute, that's a little bit differently. There's a little bit more at stake. Either there's an ongoing relationship or they want to sever the relationship and they're looking for recovery. So those are the ones that we actually do see more so going forward. So mediation really does play a huge part in it, especially for employment matters.
Very interesting. I'm seeing just one more question on this mass arbitration topic, just because it's very, very hot right now. There's a lot of services out there that are doing this to big companies. Have you seen in in arbitration provisions a no mass arbitration filing language?
I have not seen it in the dispute resolution side of it. In the thousands and thousands of cases I've personally worked on, not even our company, but personally, and seen and read the contract language, I've never seen that. And that's a very tricky situation, I would think, that will probably find its way in court at some point for unconscionability. I mean, I'm not a lawyer, so Ann, you probably have more thoughts on that, but that's a very sticky wicket. And if it does go through, I would see it being challenged quite a bit.
Yeah, I mean, I haven't seen it either. I've certainly heard the argument and discussion about that. In our jurisdiction out here on the left coast, I can't imagine that doesn't end up in court. And I can't imagine, I mean, it's more likely that I wake up and be a real blonde tomorrow than that sort of provision's upheld in California.
All right.
Yeah.
I'm just saying.
All right.
And there was a comment made too, there may be an ethical issue with that type of, which I think that's why you're hearing this feedback from us. I absolutely think so as well. I think that's a very slippery slope for a company. And it is going to be a big issue.
Well, the other issue that you have too is if you are trying to limit the number of cases that a lawyer could file, for example, in California, that would run afoul of the Business and Professions Code, trying to limit someone's practice of law. So that's another issue that comes to mind, is trying to really dictate what a lawyer can or cannot take.
And you say mass arbitration, and there's so many different ways to take that right now in terms of what is the dispute? Is it employment claims? There's a lot of different things that you can infer to that. When we've done mass arbitrations, they have such a broad spectrum of disputes. And, mass can be dozens, mass can be hundreds, mass can be thousands, not a class action, but actually a mass, tort or mass arbitration.
Right.
And what I do see is sometimes, depending on the dispute, this has nothing to do with a provision. This is just a separate topic, but it does speak to this. And that is, if you have multiple plaintiffs with very similar issues and they're bringing this lawsuit together, and perhaps you agree to a general amount of money you're going to pay all of these plaintiffs, and that's all you're willing to give, and that is it, and then you leave it up to the plaintiffs to battle among themselves who gets the pot. I am seeing those types of scenarios a lot more than the mass arbitration request scenario. And what they're looking for, you can call it an arbitrator, but they're really looking for and it's called an allocator.
Mm-hmm.
So they'll put an X amount of dollars in the pot. They have nothing to do with who gets what. They're out of it. You put the money, put it in an escrow account or however you do it. And an allocator will meet with each of the plaintiffs, structure a process. It's not a full-blown arbitration because you're not defending anything, you're not even there. So it really becomes more of an allocation. And if the plaintiff's damages are any more or less than each other, and then it's up to the allocator to decide who gets what. So I'm seeing that type of a process a lot more in different types of cases and claims. You could have two plaintiffs, but there's 50 claims involved and they're only willing to pay X amount to cover everything. So I've seen that trend.
Very interesting. All right. So I guess we're out of questions. So thank you again